this case is pretty straightforward, but it's been dragged on for over 3 years. As of right now, what ultra-vires is, according to the city of El Paso and Heinrich, is officials act ultra-vires when they exercise power without legal authority or fail to comply with mandatory limits. The defendants have essentially put forward plea to jurisdictions twice. One with other claims, the second one in relation to ultra-vires, and they've been overruled, have appealed on that same motion, on that same argument, and the Court of Appeals has upheld what the trial court. The second time we went to court to do a summary judgment where they put forward their second plea in jurisdiction, they pretty much admitted to not following their own authority. And it's pretty straightforward. All of their documentation showcases that they never at any point initiating an investigation against my client, following through with that investigation, and then putting a discharge on her, and then upholding that discharge. Never at any, even after even changing internally the documentation to say that, okay, we understand we didn't follow authority, but we're changing her status. At no point did they follow their authority. The authority that we have, which is their law, is the Texas State Guard Regulation 600, that kind of states what happens when it comes to discharges, and especially this kind of discharge that you need to have a court-martial. Then the Texas Chain of Command, the Texas CDI 2022 Investigation Guide sets the tone of who can start an investigation, who can carry it out, and what the process of it is for. The investigation is a fact-finding tool. However, in this case, it was used as a judicial process, and that's not what it's used for. Not to mention the three defendants, initiating with Janet Jimerson. She's the one who initiated the investigation. According to their guide, you must be a commander. She's in a commander, and she's not even in, or was not in the chain of command for the plaintiff. She's admitted that, and the person who made the complaint for the investigation admitted that in the investigation documentation. Fitzgerald, who then carried on the investigation and then appointed an investigator, is also not a commander. He is chief of staff, which is head of personnel. Then Joe Cave, which is the third person who essentially, after my client went to reconsider her discharge, he's the one that upheld it. He too is not her chain of command. And the CDI is pretty straightforward of who's able to carry out investigations, and it's a commander. Now, in their investigation, they cite that it says that you can use a commander or someone of higher authority. That's in their investigation paperwork, but that's not in their guide. So that's something they put in there. That's not something that's by their own laws. Outside of that, she had about 5-6 violations of culpability against her, which actually attaches to the person who commits those. So for fraud, changing documentation, those are all part of the investigation against her. However, those attach to the person to actually do it. And what they were holding to say that she did was she was the one who told someone to do it. Now, when they weren't able to catch all those violations, they kind of did a catch-all, which was a general article of behavior under Texas military. This is section 432.167. Now, even putting this on her, the next process would be court-martial. They didn't go with the court-martial. They didn't do anything. They just discharged her. Had she gone through a court-martial, she would have gone through the judicial process. She still would have been on her orders, and she'd been allowed to essentially defend herself. She wasn't provided any of that. Now, even in reconsideration, which is Exhibit L, we have one of the parties who essentially was going through the process of helping her go through the consideration, which is
Your Honor, if I may, the state objects to plaintiff's invocation of Exhibit L under Texas Rule of Evidence 701 because it is not helpful to determining a fact issue in the case. under Rule 901 because plaintiff has not properly authenticated the exhibit. Under 401 because the exhibit is irrelevant to the case and does not have a
Mr. Burse, I'm going to allow her to complete her argument, and then I'll listen to your objections to the evidence and your response to the summary judgment.
Yes, Your Honor. Thank you.
Thank you. Go ahead.
So
Ms.
thank you. Like I was saying about L. L are the communications she has for her administration remedies before Joe Cave upheld reconsideration. And it was through the tag, the OGC, and Texas.
Man, I'm sorry, you're breaking up, so I didn't catch all of your words in that last sentence. If you'll start over.
Sorry, yes, no problem, Your Honor. Exhibit L refers to the alternative administrative remedies that she went through seeking reconsideration before Joe Cave upheld the discharge. This is correspondence with the Texas offices, the OGC, and the TAG. And one of the officials in there, Stephen Autry, actually goes on to say his essentially, because he's a part of the whole process of helping her go through reconsideration, speaks about the process and even speaks to the ultra-virus acts of the whole entire process. That is in Exhibit L. Now, she pretty much, like, they've admitted to not following their process. They've tried to change it, and their argument of changing it is saying that it's become moot, which the 15th Court of Appeals has upheld. Now, during this whole process, my client she's lost her civilian job. She has not been able to work for the past couple of years. And this has been since December 2022 that she's been trying to advocate for herself. And as of right now, if she did go through a court martial and it was held that she was guilty of whatever they said she was, and she got an other than honorable discharge, this would be a different forum where we're arguing that, okay, she went through the process and we don't agree with the process, what the decision was in the process. However, right here, we're simply saying that they did not follow their own law. Their law is pretty straightforward of what you need to do. Their CDI says how an investigation is supposed to be carried out and why it's supposed to be carried out and what it's supposed to be used for. And they clearly just bypassed every single thing that affords my client protection, which her being a member, she's supposed to be afforded. So, Your Honor, according to summary judgment, summary judgment is proper when the evidence establishes that there is no genuine issue of material facts and the movement is entitled to judgment as a matter of law. There's no dispute of fact because the defendants have admitted to their own wrong act. So as of right now, this is the kind of situation that the summary judgment is pretty much set for. I do not believe, nor does my client believe, a trial is necessary for us to litigate why the investigation took place or what they were accusing her for. We already know they did not follow their law, and it's pretty straightforward. Thank you, Your Honor.
All right, thank you. Mr. Burris.
Yes, Your Honor. A couple things first off. Number one, while plaintiff did confer with me regarding the setting of this hearing, she did not file a notice of hearing. And second, at the beginning, a few minutes ago, you said that this was a non-evidentiary hearing. And so we object to plaintiff's introduction of Exhibit L on that ground.
It's a non-evidentiary hearing, but there is summary judgment evidence in the record. So I'm not saying that isn't going to be considered. I'm just suggesting no new evidence, no testimony, anything like that gets introduced at a summary judgment hearing.
Yes, Your Honor. Well, to that point, we do object to 3 of plaintiff's exhibits in her motion for summary judgment. We first object to Exhibit E under Rule of Evidence 403 because it introduces improper character evidence against Defendant Jimerson in the form of unsupported allegations. And because we further object under 802 because it is inadmissible hearsay, being offered to prove the truth of the matter that plaintiff's discharge was retaliatory and unlawful. We object to Exhibit J under Rule of Evidence 701 because it's not helpful to determining a fact issue in the case. And we further object under 401 because the exhibit is irrelevant to the case and does not have a tendency to make any fact of the case more or less probative. And I re-urge my objections to Exhibit L under 701 because it is not helpful to determining a fact issue in the case. 901 because plaintiff has not properly authenticated the exhibit. 401 because the exhibit is irrelevant to the case and does not have a tendency to make a fact of the case more or less probative. Under 403 because this exhibit's probative value is substantially outweighed by a danger of unfair prejudice because it concludes without support that plaintiff's discharge from Texas Military Department was improper. And finally, we object under 802 because it is inadmissible hearsay offered to prove the truth of the matter that plaintiff's discharge was unlawful.
All right. Thank you, Mr. Burris. Ms. Inahara, you want to respond to those objections to exhibits E, J, and L?
Okay, E, J, and L. Exhibit E is the plaintiff's affidavit. His reasoning and argument for objecting is based off the argument for Jemison. However, the argument for Jemison is that she didn't have any lawful authority to initiate the investigation. So what the plaintiff speaks about in her affidavit doesn't actually speak to the issue at hand. But the affidavit is pressed forward for them to understand the process of what she has gone through and what essentially she's lost by going through this process. So if we feel like he needs to take out what's in relation to Jemison in that's fine by us, but it doesn't take away the legal issue of this matter. And that was she did not have authority to initiate the investigation. As it relates to Exhibit J, Exhibit J does help. Exhibit J is a chain of command diagram.
Let me just stop you for a second because his other objection is that it's inadmissible hearsay. That is E.
Yeah, so that's in relation to Jemison. It's the plaintiff's affidavit. So that's what I'm saying. The hearsay that he's referring to doesn't actually weigh on any issue that we're presenting the summary judgment. Jemison's acts in here are without authority because she initiated an investigation, not being a part of the chain of command. So my client putting in the affidavit is retaliatory doesn't speak to the unlawful authority that she did not have to begin with. So that's what I'm saying. It could be, that can be stricken out. Anything in relation to Jemison can be stricken out of her affidavit, but her affidavit is put forward to showcase what she has gone through this process. Jeanette Jemison's reference is a very minute part of her affidavit.
All right. And is that the part that you're claiming is inadmissible hearsay, Mr. Burris?
Yes, Your Honor. Let me pull up Exhibit E right now.
Yeah, I'm having trouble finding it in the 161 pages of exhibits. Unfortunately,
It begins on page 49, Your Honor.
Page 49 of mine is Exhibit D, but let me see if I can find E. Closer. I got it.
Yes, Your Honor. On paragraph 4 of plaintiff's affidavit, she states that her discharge was retaliatory in nature, resulting from her disclosure of alleged budget misappropriations and subsequent hostile work environments created by defendant Jemison. She made that statement out of court, and it goes to the truth of the matter. It goes to prove the truth of the matter that her discharge was retaliatory and unlawful. Plaintiff is not qualified to make that judgment.
So, of course, we know that summary judgment motions can rely on affidavit testimony. And generally the way you deal with that is if there's a counter affidavit. Did you all file a counter affidavit?
No, Your Honor.
Okay. Then let's go on to J. Ms. Inahoro, tell us your response to his objections to J, which are based on rules of evidence 101 and 401.
Yes, so the Texas chain of command diagram actually just speak to the facts because it speaks to, it's in relation to defendant Joe Cave of showing essentially his position. He is a BG of a brigadier of the 6th Department, and my client was a part of the retention and recruitment department. He's not a part of her chain of command. So it's just to show and highlight that he was not a chain of her command.
Your Honor, this exhibit is irrelevant. For instance, on page 17, it displays the proper uniform requirements for a member of the Texas State Guard. I don't see how that's relevant at all to this case. Proper hand saluting. If there is any relevant part of this exhibit, it is a very, very minute part, and the entire exhibit should be stricken because it's irrelevant, mostly.
So the only part that we are referring to, Your Honor, is the diagram. And because it's in whole, we didn't want it to be seen as us just placing forward a document without showing where it came from is the reason why the whole document is there. So
what page is the diagram on?
the diagram should be, it's in the beginning. Sorry, I don't have it printed out. Let me go to it. And page 5 and page 6. Well, the command structure is on page 6, but the titling is on page, well, actually, it's just page 6 because page 6 is in reference to him.
All right.
So we can strike the rest of it, but I just wanted to make sure it was understood it came from a handbook and we didn't just place forward our own facts.
All right, thank you. And what about your arguments on Exhibit L? He cites, I guess, 5 different rules: 701, 901, 401, 403, and 802.
Exhibit L is put forward to show that she went through internal administrative remedies and she exhausted it. So it's put forward just like her affidavit to prove that she actually went through the proper processes of reconsideration, and she sought essentially initial help that she wasn't provided by the military.
All right. Your response, Mr. Burris?
Just that this email from plaintiff to her attorney that from 2 years ago that outlines that gives a timeline of the events up until then. Plaintiff has not properly authenticated it. It's not helpful determining a fact issue of whether or not the defendants acted ultra vires. It's irrelevant to determining whether the defendants acted ultra vires. Its probative value is substantially outweighed by a danger of unfair prejudice because it concludes without support that plaintiff's retaliation was unlawful or retaliatory. And it is inadmissible hearsay. This is an out of court statement made to prove the truth of the matter that plaintiff's discharge was unlawful.
Actually, what Ms. Inahoro says is it's offered to show she exhausted her administrative remedies.
That's still irrelevant to this. That's still irrelevant to determining whether the defendants acted ultra vires.
All right, I understand your arguments. So you can go ahead I'll take those objections under advisement. Go ahead and make your argument on the summary judgment motion itself.
Yes, Your Honor. Your Honor, plaintiff is right that this is simple. First, she has not carried her burden with respect, she has not carried her summary judgment burden with respect to all three defendants. With respect to defendant Jimerson, there is no evidence that Jimerson discharged plaintiff from the Texas Military Department, which is the act that plaintiff complains of. All Jimerson did was report allegations to her superiors in the Texas Military Department. The plaintiff paid people to falsify orders for her. Similarly, Your Honor, against defendant Fitzgerald, plaintiff has presented no evidence that Fitzgerald did not have the authority to appoint an investigator or to discharge plaintiff after the investigator found that the allegations against her were substantiated. And finally, plaintiff presents no evidence that any action taken by defendant Cave does not fall within the discretion of General Cave. General Cave found that the allegations against plaintiff were substantiated and dismissed her. That is within his power. Fitzgerald appointing an investigator is within his power. And Jimerson reporting allegations of falsified orders is within her power as a member of the Texas Military Department. At all times, these defendants acted within the best interest of the agency. And for that reason, plaintiff has not met her burden of summary judgment. Further, Your Honor, this is the second time we have had a hearing on plaintiff's argument for summary judgment. The only thing that has changed between the first motion for summary judgment hearing in July of 2024, in which the court denied her summary judgment on all claims, is that the court has established its jurisdiction over plaintiff's ultra vires claim. There are no other changes in the legal circumstances of plaintiff's argument from 2 years ago to now, when it was, or 2 years ago when it was denied to now. There's no reason that disposition, that attitude of the court should change, because there simply hasn't been any discovery conducted at all. We have not given plaintiff any evidence that she would need to support or to prove her claim. And she has already tried once on this claim. She failed. She tried twice.
Your Honor, I would like to. What he's saying is actually not factual to what's on the record.
So, Ms. Inahora, I'll give you an opportunity to respond when he's done.
Thank you, Your Honor.
Go ahead, Mr. Burrs.
Thank you, Your Honor. Plaintiff has provided evidence, and evidence contained in our response to her motion for summary judgment, that the allegations against her leading to her discharge were substantiated after an investigation conducted by the Texas Military Department. Plaintiff complains of her discharge status and an other than honorable discharge. Your Honor, to the extent that that was a mistake, Texas Military Department has rectified it. We changed her discharge status, and her initial discharge status is the result of a clerical error, Your Honor.
And you changed it to what?
We changed her discharge status to one that does not require a court-martial. I don't remember the exact status. It's been a while.
It was a general, is what it was changed to.
Yes,
But
we changed it to a general
code
discharge.
as a dishonorable discharge, the TF4 code.
Because, Your Honor, that appears only within Texas Military Department's internal system. There is no option in the system to change that from an other than honorable discharge to a general discharge.
I'm sorry, you can't change it from other than honorable to what?
to general in the Texas Military Department's internal system because it does not, for some reason, have that capability.
All right. So y'all came up with a reason for the discharge later that isn't in the system.
No, Your Honor, we changed her we changed her status. The reason for her discharge is that allegations that she falsified Texas Military Department orders were substantiated and upheld. She was discharged in an other than honorable discharge status, which requires a court-martial. She was not provided a court-martial. And we believed that after she was discharged, after this litigation was initiated, that we would change her discharge status to one that does not require a court-martial.
All right. Your response, Ms. Inahara?
Yes. The defendant's counsel mischaracterizes like half of the record. One, for the investigation, as said before, the CDI investigation guide is the Texas Military Department's own guide, not something we came up with, not something that's made up. And it says specifically who can initiate an investigation, a commander. Jeanette Jimerson is specifically named in the investigation as a claimant, which means she initiated the investigation. She is not a commander. Fitzgerald is also chief of staff. He carried out the investigation, and then he appointed an investigator. He had no such authority to do so. Then for reconsideration, he then
Say that person's name again.
Darren Fitzgerald.
All right. And he's also not a commander.
Nope, he is chief of staff. Then the third person, Joe Cave, which as named here, and the reason for the command chart is he is a BG in the 6th Brigade. Again, my client was in the retention and recruitment department. None of these people are a chain in command. It's in their investigation paperwork admitted that the initiation from Ms. Jimerson, that she is out of that chain of command. That's one. Two, in the investigation, what he said is that she was tried for falsifying documents. Actually, what the investigation put there is that they could not find she was guilty of that because she did not falsify the documents. The person who falsified it admitted themselves that they did. They were saying that she told them to do it. So because they could not uphold any of those things, they just did a catch-all, which, as named before, is that 432-137, which is what they used to uphold something against her. But it wasn't for falsifying documents, and their investigation says so. Now, going to the actual record of everything, because of what they were holding against her, there needs to be a court-martial. That's something that needed to be done in 2022. It's a court-martial. Now, they did not provide her by that. They used the CDI, which is an investigation tool, which would mean that the information they get from that would be used in the court-martial. They didn't even give her a court-martial. They just discharged her. Now, in the first summary judgment, when we brought this forward, what was held in court, which is why I said he was incorrect, because she brought up the reasons for the investigation, the court denied those reasons, but they upheld the ultra-virus claim, which is why we are still here talking about the ultra-virus claim. Last year, we attempted to do summary judgment, and the defendant brought up another pleaded jurisdiction, which is his second pleaded jurisdiction, but now solely focusing on the ultra-virus claim, and it was overruled in the trial court. Then, like he just said, 2 years later, and they didn't even give her discharge documentation till February 2024. So even though they discharged her, she didn't get her certificate of the discharge till February 2024. They now in April of 2025 decided to say, oh, we agree we did not follow the court-martial, but we're going to internally change your status. They changed your status, which they had admitted that their records and their own system does not provide for, even though it was still upheld the same coding as a other than honorable discharge. So though they changed the wording basically for cosmetic like providing, it still had the same coding as other than dishonorable. And that's in exhibits F and G, showing what it was before and showing what it was after having the same code. They now, after their last plea to jurisdiction was overruled based off of what he just said, which the judge, your system doesn't provide for it. So how do you say that's a remedy for her? They now then appealed on this. The 15 appellate court agrees that this is not a remedy. Your system doesn't provide for it. And she basically is still having an issue because he tried to argue that it was moot. So I wanted to just clarify that
I'm trying to argue that you haven't established your...
Hang on, Mr. Burse. All right, you're about out of time, Ms. Inahura, so let's go ahead and wrap up.
Yeah, so just wanted to clear the record that the Authorized claim actually has been upheld and it wasn't denied by court. And then also, pretty much when it comes to a Vires Act, it's not the ending act, it's the full breakdown of it, how it was initiated and how it was ended. Jeanette Jemison initiated the investigation, which she had no authority. Fitzgerald did the first discharge, also carrying out the investigation, and Cave now upheld that discharge. And as pointed in my supplemental argument, is the whole entire process was without authority.
All right, Mr. Burris, how much time does he have left?
About 45 seconds.
All right, Mr. Beck says you have about a minute left.
Okay. Your Honor, all that has been decided in this case is that the court has jurisdiction over plaintiff's ultra-vires claim. I am reading from an order from August 8th, 2024, signed by Judge Karen Crump, that plaintiff's motion for summary judgment is denied in full. There have been no change in any legal circumstances since then. Plaintiff's ultra-vires claim is alive. This court has jurisdiction over it, but she has not met her burden for summary judgment. Further discovery and potentially trial will be needed to decide this final issue in this case. Thank you.
All right. I'm going to take this under advisement. Ms. Inahura, I'm going to tell you that I understand that you would like to resolve this as quickly as you can because it's been dragging on for so long. Having been filed in February of 24, so we're 2 years into the litigation, but the actual acts in question were in 22, is that right?
Yes.
I'm not sure that a summary judgment is your fastest route to resolution because they're just going to appeal it again. I'll take this under advisement, take another look at it after having heard your arguments, and we'll let you know my ruling as soon as I can.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Y'all are excused.
Thank you.
Thank you.